Good afternoon, everyone. Thank you for joining us today. We have a lot to cover, so I'm going to just get started now as folks finish logging in. Thank you for joining us today for CILA's 5th annual Roundup training for 2022. My name is Serena Bhatia, and I am a senior staff attorney at the Children's Immigration Law Academy, or CILA for short. To get started, we welcome you to say hello in the chat. Click on it so it says to panelists and everyone. You can include your name and organization or firm. And again, we are grateful you are here today with us for this training. As a brief intro to who we are, CILA is a project of the American Bar Association. We are a legal resource center, a capacity building organization, and a primary reason we do this work is we think every child should have representation. CILA is based in Houston, Texas. We provide technical assistance regarding case-specific questions relating to children with immigration cases. We offer quarterly working groups to provide spaces for advocates to collaborate nationwide. We provide trainings such as this one and written resources. And we host a platform featuring pro bono opportunities across the country and provide resources related to pro bono. CILA has a small but mighty team of 11. During today's training, you will hear from 7 of us, so we will each introduce ourselves as we speak. And our biographies are online on CILA's website. Oops, sorry. As we gear up, there are a few housekeeping matters I'd like to cover. So the training is an hour-and-a-half long. If you have questions, please use the Q&A function rather than the chat box to submit them. We will not have time for a Q&A at the end, so we will try to answer questions in the Q&A box as we go. But if there are any questions that we don't get to, please follow up by submitting a technical assistance request, and we will be happy to provide additional guidance directly to you. Similarly, if you have case-specific questions, please submit a technical assistance request outside of this webinar. This training is being recorded. CILA will post it on our website in the next couple of weeks. For this webinar, closed captioning is available. And you should have received PDFs of the slides and handout via email this morning. We will email them out again following the training, and we should be able to post them in the chat in a little bit as well. This course has been approved for 1.5 hours of Texas CLE credit, including 0.25 hours of ethics credit. Following the training, we will provide a survey for feedback and a survey for CLE, where you can request Texas CLE credit for attending, or if you are licensed outside of Texas, please still complete the survey, and we'll provide a letter certifying your attendance. Okay. So we call this the annual roundup because we will summarize the major changes affecting children's immigration law over the last year. Since there have been so many changes, we don't have time for a deep dive, but we will go over the key changes at a high level. We will include some practice tips and ethical considerations for litigating in a constantly changing environment, as well as resources to guide you along the way. The webinar will go over the changes that have occurred since the last CILA Roundup webinar in December 2021. Specifically, we will provide updates related to working with unaccompanied children, special immigrant juvenile status and adjustment of status, asylum law, UNT visas, and practicing in immigration court. For today's webinar, we also created a victory board where you can share a success from this past year. We did this exercise at last year's Roundup webinar and wanted to do it again. Looking back, this year has brought its own challenges with the long-term effects of the pandemic and in immigration law. While some things have improved, some things have not. So we wanted to come together at the end of the year and celebrate each other and everyone's hard work. We're going to do this through Slido towards the end of the webinar. As we present today, if something comes to mind that you would like to share with us, jot it down, and you'll have an opportunity to share it towards the end. With that, I will pass it on to Marisa to speak about self-care.
Sorry. Thank you, Serena. Hello, everyone. My name is Marisa Barrera. I'm a social worker here at CILA. Thank you for joining us today. Here at CILA, we strongly believe in the importance of self-care, as Serena mentioned. Therefore, we try to always incorporate it in most of our trainings and resources. And this webinar is not an exception. We're about to embark on a whole year of information on children immigration law, and that can be a lot. I suggest that before we get started, it will be important for all of us to prepare ourselves mentally, emotionally, and physically to receive all that information that will be coming our way. A great and effective way to do just that is by centering and grounding ourselves and setting our intentions or goals for whatever we're about to do. This will allow you to wind down from whatever you were doing previously, and it will allow you to fully be present, prepared to receive not only that information, but the emotions and feelings that it might bring up. Ideally, this is something done first thing in the morning, but it can be done at any time you want or need it. I would like for all of us to take a few minutes and to do just that. Are you ready? Can we go to the next one, Serena? Okay. Sit in your chair in a relaxed posture. Close your eyes and connect with the sensations of your seated body. Make sure your spine is straight but not rigid. Take 3 long, deep, nourishing breaths, breathing in through your nose and out through your mouth. Then let your breath settle into its own rhythm as you simply follow it in and out, noticing the rise and the fall of your chest and belly as you breathe. Do that 3 times, please. Then ask yourself, what are your intentions for today? It can be more specific, like what is my intention for this webinar? Why am I here? What do I hope to get out of it? You can use the following questions as prompts to help you set your intentions. You could ask yourself, how can I open and be prepared myself to receive that information that is about to come my way? How can I show up today to have the best impact? What do I need to do to take better care of myself? During difficult moments, how can I be more compassionate to others and myself? How can I feel more connected and fulfilled? Once you have explored your intentions, you could set your intention for today. For example, my intention for today is I will be kind and patient with myself and others. I'm going to be intentional and thoughtful with my actions. Throughout the day, check in with yourself. Pause, take a deep breath, revisit your intention. Do not lose your purpose. Correct if you deviate, and ask yourself before each situation or decision, does this bring me closer or further away from my goal? Be mindful with your intentions and actions. Remember, mindfulness does not have to be complicated or intimidating. It simply means to be present in the moment, to notice, to listen, to smell, and to embrace the whole moment. Also, throughout this webinar, I want you to honor your needs. If you need a moment to stretch, take a deep breath, drink some water, use the bathroom, whatever you need, please do so. Thank you so much for joining us today.
Hi, everyone. I'm Nadia Danilovich, a senior staff attorney with CILA. I'm starting us off today by talking about updates in working with unaccompanied children from the past year. I'll be covering ethics, a common thread throughout today's webinar, statistics and policy updates, and litigation updates. So while there are not any major updates to ethics from the past year, we still want to start off by reviewing some of our ethical duties. Competence, diligence, and communications are running themes throughout this presentation. Sometimes it can be hard to keep track of all the changes and to navigate the changes in a case. Yet it's essential to meet our ethical obligations. We must provide competent representation to a client. In the comments to ABA Model Rule 1.1, it says, to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice. We must also act with reasonable diligence and promptness in representing our clients. This is per Model Rule 1.3. And finally, we must communicate with and keep our client informed and consult with them about their case, per Model Rule 1.4. So again, we want you to keep these ethical duties in mind as we dive into our 2022 Roundup. To get a sense of how many unaccompanied kids we are all serving, it's helpful to look at data from CBP and ORR. In 2022, CBP apprehended about 52,000 unaccompanied children. When turning to ORR data, they have only publicly published data from fiscal year 2021. The average length of stay in ORR custody was down to 37 days, which is a great improvement given that it was all the way up to 102 days in 2020. ORR discharges also grew steadily in 2021, with about 17,000 releases in the month of August alone. You can see from both agencies that in 2022, Title 42 impacted the number of unaccompanied children entering the United States. And it also likely impacted their length of stay and discharge from ORR custody, especially if their parents or sponsors were impacted by Title 42 as well. So turning now to our first policy update, this year in July, ORR released a policy letter on serving LGBTQI+ youth. This policy letter supersedes two former letters, ORR State Letter 1506 and ORR State Letter 1403. So per the new policy letter, ORR interprets the Refugee Act to prohibit discrimination on the basis of sexual orientation or gender identity for beneficiaries. So this is in line with Biden administration directives, and the letter specifically states that ORR grantees must recognize the legal and civil rights of LGBTQI+ ORR youth when determining access to and providing services. The letter covers three sections. First, general recommendations for all ORR staff, then program-specific measures for shelters, and finally, resources and technical assistance available to ORR staff in serving these youth. While the letter is created for ORR staff, it can still be helpful to us as advocates who represent these youth in pushing for their needs while in ORR custody. So just last month, ORR published Field Guidance number 21, which supersedes previous guidance number 20. And this field guidance revises policies and procedures, expands those policies and procedures to apply nationally, and provides additional instruction to ORR staff regarding when children in ORR care are pregnant and request an abortion. So ORR must now prioritize placing pregnant youth in shelters in states where abortion has not been banned. If a child is in a shelter where abortion is banned and then requests access to an abortion, ORR must transfer that youth to another state to receive care. The guidance also requires that ORR intake teams prioritize pregnant teens and act within state law regarding abortions. The revised field guidance also advises staff on how to provide resources to pregnant youth. Also last month, about a week after the new field guidance was published, ORR held a stakeholder call. They confirmed that service providers can qualify for an exemption if they have a sincerely held religious belief. While ORR is aware of which providers currently qualify, they are not making that list publicly available. So if you represent pregnant youth in states that ban or restrict abortion, it is your ethical duty to review this field guidance and use it to advocate for your client's transfer to a state where their abortion access and rights are not restricted. Turning now to abuse in ORR custody, while abuse, including sexual harm, has always been an issue, it's important as advocates to familiarize ourselves with the issues and stay on top of reporting requirements. The standards governing abuse in ORR can be found at 45 CFR 411.11 and in the ORR policy manual at Chapter 4, Section 3. Both sections lay out the zero tolerance policy that ORR has towards all forms of abuse, including sexual abuse. Section 4 of the ORR Guide provides an outline for and guidance on their approach to preventing, detecting, and responding to such conduct. ORR is required to have written policy and employ prevention of sexual abuse, or PSA coordinators, at both the headquarters and shelter levels. At a recent ORR stakeholder call, they stated that they have added significant resources to improve collection of data. They are doing daily review of sexual abuse, significant incident reports, or SIRs, and they are providing funding and oversight for on-site audits. They also shared that all sexual incidents are reported directly to state and local authorities. While it's hard to find consistent, reliable, and publicly available data on this, at a recent stakeholder call, ORR shared that there were about 2,000 SIR allegations of sexual abuse from January to August of this year. There was also a congressional report in the past few years that found about 7,000 reports of sexual misconduct in OR care from fiscal years 2016 to 2020, with those reports peaking at about 2,700 in fiscal year 2019, right before the COVID-19 pandemic. In the handout that goes along with this presentation, you'll find links to the congressional report, as well as further news articles with even more data. Finally, while we know that OR staff have their own reporting guidelines, we as legal staff must follow jurisdictional requirements and our own state bar's ethics rules. So for those in the VERA network, you can find VERA's guidelines called Responding to Situations of Abuse on their SharePoint. In some states, attorneys are mandated reporters, while in others we must weigh whether imminent harm to the child or others require us to break confidentiality. So this is something to keep in mind in any case of abuse that you encounter. I also want to discuss some federal licensing issues that have occurred in Florida and Texas in recent years. So in 2021, Texas and Florida pushed to shut down OR shelters by threatening to pull their state licensing or not renew their licensing. This led to great concern that hundreds or even thousands of children would have to be moved quickly to other states at a time when ORR already had high numbers of children in care throughout the country. In October of this year, a shelter called His House in Florida filed a suit against DeSantis's emergency order that licenses not be renewed. That shelter recently announced they're settling the case, which means they will likely be granted license renewal. In response to these federal licensing issues, the government put out a request for information with the hopes of creating a proposed rule to deal with this issue in the future. If this proposed rule came to fruition, it would provide a regulatory framework for any OR shelters in states where their governments were restricting access to state licensing. It would create an office to manage this new federal licensing. It would be located within the Administration for Children and Families, but not within ORR. The rule will incorporate Florida Settlement Agreement standards. We do know that ORR is continuing to have listening sessions on this issue, and so keep an eye out for those and a hopefully forthcoming proposed rule. Turning now to litigation, I want to start with two updates about Flores. So in May of this year, after 2 years of negotiation, the parties submitted a joint motion for preliminary approval. It focuses on the RVG and El Paso sectors of the border. It requires CBP to designate at least 2 facilities as juvenile priority facilities. CBP also agreed to a wide range of protocols that require minors be held in safe and sanitary conditions. This includes access to showers, age-appropriate meals, clothing, mattresses, blankets, medical care, and much more. CBP must treat minors in custody with dignity, respect, and special concern for their particular vulnerability as minors. They also must place children in the least restrictive setting and keep them with family members except when not feasible. This is pending approval from Judge Dolly MG. In June, the parties also submitted a proposed stipulated settlement following the plaintiff's motion to enforce the settlement agreement at EIS sites in particular. If approved, the settlement will require that EIS sites provide suitable living accommodations, daily outdoor activity, private phone calls for 10 minutes at least twice a week, and weekly meetings between case managers and unaccompanied children. The agreement also prohibits placement of particularly vulnerable children at EIS sites. Lucas Art is another important case that happened within this last year. So in August, the same judge, Judge Dolly G, issued a preliminary injunction requiring ORR to provide youth in federal immigration custody with due process. ORR must provide clear and convincing evidence of sufficient grounds for stepping up a child or continuing to keep a child in a restrictive placement. So this includes both secure and staff secure shelters within the ORR network. In addition, a notice of placement, now known as an NOP, must be provided to minors, their parent or legal guardian, and their counsel within 48 hours after the step up. ORR must automatically serve a new NOP every 30 days the minor remains in a restrictive placement. This injunction took effect in October, and per another recent ORR stakeholder call, they shared that they are having ongoing meetings with federal field specialists to make sure rollout is smooth. Moving on, we have Duchitanga v. Lloyd. This case dealt with fingerprinting requirements for sponsors. The specific fingerprinting requirement for the reunification process was adding weeks or even months for the process to be completed. Some sponsors were also scared away from the process because of the fear that ORR was information sharing with ICE. So the ACLU of New York filed suit, and during the course of proceedings, the government lessened the requirements and opened up more sites to deal with the delays. The case eventually settled this year and resulted in new deadlines. Now, the government must schedule fingerprint appointments within 7 business days. And once that appointment takes place, the processing of the fingerprints must take place within 10 business days. And finally, Garcia Ramirez. This case dealt with age outs, that is, children who turn 18 in OR custody and then end up in ICE custody. So ICE was not considering the least restrictive placement for these youth. Instead, they were automatically sending them to ICE detention, even when they had sponsors willing to take them in. So on September 7th of this year, the district court approved a settlement agreement wherein the government agreed to dismiss their appeal, and a permanent injunction has now become final. So going forward, ICE officers must complete a case worksheet for each child aging out of OR custody, and they must determine if there is a suitable sponsor or group home to place them in, rather than adult detention. The settlement requires ICE to retrain its officers, fill out this new paperwork, revamp their training and policies, and provide monthly reports and documentation to class counsel. Class counsel will continue to monitor ICE's progress and compliance through September of 2026. This is also likely the reason that ICE created and is rolling out a new alternative to detention program called the Youth Adult Case Management Program, in which a contracted service provider will hold regular check-ins with released young adults ages 18 to 19 and refer them for social services. We've heard that this program is being rolled out next month, January 2023, in San Antonio, and eventually expanding to 16 cities. And that is it from me today. Next up will be Dahlia discussing SIJS.
Hi, everyone. My name is Dahlia Castillo Granados, and I am CILA's director. So there's been a lot of changes with special immigrant juvenile status, and I think overall really positive. So we're going to start with the regulations. As many of you know, the regulations were last promulgated in 1993 before many of the changes that came about through statute, most notably in 1997 and with the TVPRA in 2008. There was a proposed rule that was released in 2011, but it was never finalized. And in lieu of any regulations, USCIS did release a policy manual, which made significant changes to the SIJ program. That also led to increase in requests for evidence, notices of intent to deny, and even denials of SIJS. The rule was re-released once again in 2019 for an additional period of comment, and it was finally finalized this year. And the rule went into effect on April 7th of this year. You can find the rule published in the Federal Register, and one of the things that's helpful about that is reading some of the commentary from the agency. You can see the initial proposed rule, some of the comments that came in, and then the reasons why USCIS is abiding by the comments or not. The regulations at 204 discuss everything related to SIJS petitions, from the definitions to eligibility, what's required in the court order, the petition requirements, and how USCIS is going to adjudicate those petitions. 205 discusses the revocation provisions, which are actually now in 204, but it does reference back to that provision. And then the regulations at 245 are discussing the SIJS-based adjustment of status rules. So one of the major changes, and really a positive change, is that marriage is no longer an automatic revocation provision once the I-360 has been adjudicated. So now the rule says that a petitioner has to remain unmarried at the time of filing and through adjudication of the I-360 only. So this is a significant change and really positive, because we know that many SIJs wait years before they can adjust status. And this was really preventing them from moving on with their lives. And marriage was did create this automatic revocation provision before they were able to get their green card. During the stakeholder meeting that happened this year with USCIS, they did also make clear that any petitioner remains eligible for adjustment of status if they married after adjudication of the I-360, even prior to the change in the regulations, as long as they did not receive a revocation notice from USCIS. There are some new definitions in the rules, and so I just wanted to point out two of those. So I know as practitioners, we're used to saying that the requirements in the court order are findings. Now USCIS has this new definition of judicial determination, which means a conclusion of law, and the USCIS policy manual has been updated as well to reflect this change. And the second change is the definition for a juvenile court, and this makes clear that the state court has to have jurisdiction either for the child's custody or dependency. So even though the statute had that or, now the regulations make clear that the only requirement is for custody or dependency. Another important change is to the consent function. The consent function was introduced into the SIJ statute in 1997 when there was allegations of abuse in the program. And so Congress wanted to make sure that the agency adjudicating these petitions had the authority to look at whether or not the claim was bona fide. And what they meant by that was whether or not the child was seeking relief from parental mistreatment or simply an immigration benefit. So one of the positive changes in the regulations is that it removed any reference to consent being a discretionary function. So the initial proposed rule had read a discretionary element into the consent function. And so that has been taken out, and you can see some of the comments related to that in the Federal Register. And then, the bona fide language still remains, but USCIS, now, shows that they see that there can be a dual or mixed motive for why a child is getting a state court order. And so instead of being the primary purpose, obtaining that state court order, the primary purpose just being from relief from parental mistreatment, they understand that it could be for a primary purpose. So that language has changed. And how you prove that you warrant consent, well, USCIS, the agency and the regulations say that you need to show the factual basis, which, we were already aware of because that language is part of the USCIS policy manual, but also makes clear, and this was also part of the manual, but now is integrated into the regulation, that you need to show relief from parental abuse, abandonment, neglect by either a custody determination or a dependency determination. And if it's a dependency determination, showing that there's protective or remedial relief that was ordered by the state court. And that can include placement with ORR. There are some, individual claims for relief that I've identified here at the bottom that are contesting this additional requirement for dependency orders. The most recent case is Cosme v. Garland. That's for a dependency order out of Massachusetts, and it did survive a motion to dismiss, and the court found that the statute doesn't include this additional requirement for dependency determinations. Another one of the major changes that came about in the regulations is the requirement for continuing jurisdiction. So whereas before the requirement was that there be continuing jurisdiction of the court through adjudication of the adjustment of status, now it makes clear that it's only through the adjudication of the I-360. There are some exceptions to this requirement. So if the petitioner was adopted, placed in a permanent guardianship, or has reached some other child welfare permanency goal, which is a pretty wide standard, then that is also an exception. And of course, if the order terminates based on age, then that would be a second exception for the continuing jurisdiction requirement. Similar basis is one of the ways that you can show that reunification is not viable. And so here USCIS is making clear what they're looking for when you claim a similar basis. So there must be evidence of how the basis is legally similar to abuse, neglect, or abandonment. And you can show that either through the court's own determination as to how the basis is legally similar, or through some other evidence. The time for adjudication is one of the provisions that was changed with the TVPRA of 2008. And, the statute said that SIJ petitions had to be adjudicated within 180 days. And so now the regulations state that, although it's, it gives USCIS pretty wide latitude. So it says that generally petitions will be adjudicated within 180 days, but that clock doesn't start until all evidence has been received by USCIS. And then there's provisions here that talk about when that clock can be stopped and then reset. So there is some continuing litigation around this, this provision. There's a case out of Washington, Moreno-Galvez, that just had a recent decision from the Ninth Circuit, affirming the lower court's permanent injunction, saying that enforcing that 180-day deadline and, contesting that tolling for RFEs and NOIDs. And so that applies to a putative class of SIJ petitioners in Washington State. There's also another case, Casa Libre, Freedom House, that's for a putative class of SIJ petitioners nationwide, and it just survived a motion to dismiss, so the case can continue regarding violations of the 180-day deadline and then contesting that stop time rule that's now in the regulation. So as I mentioned, the revocation provisions are, they're at 205.1, which just references back to the 204 provisions. Something new is that it states that USCIS will issue a notice of automatic revocation and will actually give the petitioner a chance to, or the SIJ, a chance to respond to that automatic revocation. And the only two reasons for automatic revocation stated are if there's a reunification by virtue of a court order, or if through some sort of administrative or judicial proceedings, the court finds that it's in the best interest for the child to return to their home country. And then, there's also just a general revocation provision as well. So the regulations at 245 also integrated the additional inadmissibility grounds. There's some inadmissibility grounds that are waivable by SIJs that came about through the TVPRA, so it integrates those. And then one more, positive change is that the new regulation does codify the holding in matter of Moradel, which is a case from the BIA that makes clear that you can seek a waiver for the 3 different grounds of inadmissibility. So an immigration judge had read that statute and found that their waiver for simple possession of marijuana only applied to 212A2C, but the BIA and now USCIS makes clear that you can also ask for that waiver if the inadmissibility ground applies to 212A2A or 212A2B as well. So now we're going to turn over to some trends some trends from the AAO. That's the Administrative Appeals Office, which adjudicates, appeals from I-360 denials. So NIP NLG has an index that they publish quarterly on AAO decisions. So some cases that I wanted to highlight, the first is on deceased parent cases. So the AAO here makes clear that there has to be a finding or determination that death constitutes abuse, abandonment, neglect, or a similar basis. So I have 2 cases here, and neither one of these did the AAO agree that there was sufficient requirements, but one of the ones that I wanted to highlight is the second one here, where the petitioner alleged that there was abuse, abandonment. There was abuse or abandonment prior to the parent's death. And the AAO said that if that was the case, then the state order should have stated that. So that's just one way to think about maybe overcoming, this requirement. If there was abuse, abandonment, or neglect even prior to the parent's death, if the state court is not willing to make that death is abandonment or death is neglect finding. The second set of cases here is on the sufficiency of best interest determinations. We know that some state court judges aren't comfortable in making that best interest determination. And so in this first case, the AAO found that there was a qualifying determination on best interest, despite there being no explicit language in the order. And then In the second case, they found that there was not a qualifying determination because there was, nothing in the order that could be interpreted in that way, and the language was only found in the petition. And then just a few more cases here on the court acting as a juvenile court, which is the issue of where the state court order is made after the child turns 18. So there's some states that have that extended jurisdiction provisions. And so what the AAO says is that you have to cite to the state statute that authorizes that extended jurisdiction. And so I have three cases here, one out of Virginia where the state court judge actually backdated the order and cited to the statute that allowed him to do that. So the AAO found that they were acting as a juvenile court. In Texas, with child support cases, if you cite to the definition of a child under the child support statute, then the AAO has found that the court was acting as a juvenile court. And in the final case here out of Colorado, the order did not cite to any state statute, so the AAO found that they were not acting as a juvenile court. On consent, I wanted to talk about two different issues. The regulations, you do talk about inconsistencies found in the record, and that being one of the reasons why consent's not warranted. So in this first case, they did find, the AAO found that consent was warranted when there was a reasonable explanation as to why there was a discrepancy between a statement to CBP and what was in the state court order. And in the second one here, consent wasn't warranted when the petitioner didn't overcome statements that were made at the consular interview by the child and their parent. And then on the issue of protective or remedial relief, in the first case, consent wasn't warranted when the AAO found there was no protective or remedial relief in a dependency case. And then the second case, consent was warranted where the child was in ORR custody. So moving on now to the issue of the SIJS backlog, which we know is a huge issue, and especially now with the December bulletin just coming out, and now we see that there is a backlog among SIJs from all countries. So as before, there was a backlog for SIJs from El Salvador, Guatemala, and Honduras, and this has been ongoing for many years since May of 2016. India at some point was also backlogged early on. Mexico has been backlogged very recently, but now children from all countries must wait for a visa number to become available before they can adjust their status. And the reason for this is that there's a limited number of visas that are available. So it's 7.1% of the 140,000 visas available. And on top of that, there's also a 7% country limit. So this is why you see the differences between the countries. Now, there was some rapid movement of the priority date, you might have noticed in recent years, but that's because there were some, because of the pandemic and closing of consulates abroad, there were some additional family-based visas that were available that got rolled over into the employment-based categories. And so that's what caused there to be some additional visas and some rapid movement of the priority date. So for this year, there were some additional visas from those family-based categories that got rolled over into the employment-based categories, but definitely not enough, obviously, to meet the demand. And so it's important to keep in mind that, you can't read the visa bulletin to try to guess how long the child will have to wait before they can get their green card, because that only takes into account, the visas that are available each year and not the amount of petitions that have been filed. So the Cato Institute has done some modeling to try to guess how long people would have to wait. So you can see here that SIJs from El Salvador, Guatemala, and Honduras definitely have a very long time to wait before they can get their green card. So there's definitely been some advocacy on this issue. The End SIJS Backlog Coalition and the American Bar Association have both called on exemptions from the numerical limitations for SIJs. And there's been some positive movement on that ground, both administratively and legislatively. So, my colleague Sachi will talk about deferred action, which is wonderful development that happened this year, protecting SIJs from removal and giving them access to employment authorization. There's also been agency advocacy, both at USCIS and ICE for SIJS youth. And we know that, ICE continues to use prosecutorial discretion to, so that SIJs aren't at risk of removal. And there's been a return of some docket management tools at EOIR for termination and status dockets that will protect SIJs. On the legislative side, there are now 3 bills that are that call for the exemption of numerical limitations for SIJs. And additionally, in the Appropriations Act for this bills for this year, both the DHS appropriations bills on the House for the House and the Senate, it does call for the numerical limitations, exemption of numerical limitations for SIJs, and we'll see what happens with the omnibus that will be voted on at the end of this year. But all of this progress is very positive. And now I'm going to turn it over to my colleague Sachi.
Hi, everybody. Good afternoon. My name is Sachi Denham-Hand, and I'm a staff attorney here with CILA. Thank you all for being with us today. I'm going to go over deferred action, as Dahlia said, and afterwards I'm going to go over asylum very briefly. First, going to go over deferred action. This was a very huge update for SIJS petitioners this year. In March, USCIS announced that they would grant deferred action to SIJS petitioners waiting for their priority dates to become current, waiting for a visa to become available so that they can apply to adjust status. For context, right before this announcement, the visa bulletin had just retrogressed by nearly 2 years, rendering more petitioners in a position of waiting for a visa to become available. There are limited numbers of visas available each year, and this limited number does not take into account the number of petitions that have actually been filed. So these grants of deferred action seek to alleviate the difficulties that one may encounter while they wait to apply to adjust status. While it was announced in March, the official rollout of deferred action started in May, when certain SIJS petitioners received with approved I-360s received notification online with Form 797s and via mail with Form 797s and online that they had received deferred action. The official policy regarding deferred action is in Volume 6 of the USCIS Policy Manual, and you can still view the deferred action announcement on USCIS's website. So just to be clear, deferred action for SIJS petitioners, it is a grant of prosecutorial discretion. It does not grant lawful status. Rather, it prevents the physical removal of the SIJS petitioner from the United States during the period of validity of the deferred action. It applies to those who have been classified as SIJS petitioners before, on, or after May 6th of this year, based on whether the individual has an approved Form I-360. The trend for recent I-360 approvals is to receive the grant of deferred action in the approval notice itself. It is granted on a case-by-case basis. There is no need to actively or separately apply for deferred action. Rather, USCIS independently reviews and determines who receives this deferred action, and then they notify the individual via mail and they update their account. This grant of deferred action lasts for a continuous period of 4 years. And very importantly, the grant of deferred action allows SIJS petitioners to apply for work authorization under the C-14 category. This is a very positive outcome of the deferred action rollout, as SIJS petitioners waiting on visa availability prior did not have a clear path to employment authorization. As I stated before, it is granted on a case-by-case basis, and in doing so, USCIS weighs positive and negative factors in one's case and then determines whether or not they will receive deferred action. Positive discretionary factors include, obviously, whether they have an approved Form I-360 and whether the petitioner meets underlying SIJS eligibility criteria. Negative factors, though, that may weigh against someone receiving deferred action from USCIS include admissibility grounds that cannot be waived, which would be shown on background checks, and serious unresolved criminal charges that may later result in inadmissibility grounds that can't be waived. Deferred action lasts for a continuous period of 4 years. However, if a visa is still not available for the petitioner 150 days before the deferred action is set to expire, the petitioner can then submit a renewal request to USCIS at that time. One of the most significant aspects is the EADs for SIJS petitioners with deferred action, and the SIJS petitioners with deferred action can apply under the C-14 category. These EADs given to deferred action recipients last for the 4-year validity of the deferred action itself. And some practitioners have experienced that the processing and receiving of these EADs is quicker than other categories, such as the asylum-based category. The CILA team has compiled some practice tips for y'all regarding applying for the deferred action EADs in the C14 category. First, be sure that your client's address is current with USCIS so that they can receive their deferred action notice to the right address, and you can update their address online on USCIS's website. Another thing to be sure of is the lockbox address to send the actual EAD application to. Be sure to check online and make sure that you're sending it to the correct lockbox address, as this address to receive the C14 EAD applications does tend to change. Another tip is that USCIS released a new version of a new edition of the I-765 application for employment authorization this year. Starting January 3rd, 2023, in less than a month, USCIS will only accept this new edition. So make sure that you are using the right edition when you are sending these EADs. And importantly, you can use the form I-912 to waive filing fees. And USCIS has stated that the policy applied to this fee waiver is the same policy applied to the I-485 adjustment of status fee waiver. Continuing with the practice tip, this applies if you have a client who qualifies for dual relief, such as asylum and SIJS. If the client receives deferred action, but they already have an asylum-based EAD, they can apply for the C14 EAD only upon renewal of the C8. So when it's time to renew the C8 EAD, when it's expiring, then they can apply for the C14. That actually wraps up deferred action. So I'm going to go ahead and start with the asylum overview. So 2022 has been a quieter year regarding legal updates for unaccompanied children and asylum. There have been some updates for adults qualifying for asylum, not as many for unaccompanied children. So we do have some brief updates and reminders for you all. An important case reminder is the JOP preliminary injunction, which is still in place. The injunction requires USCIS to accept jurisdiction over unaccompanied children's asylum cases if the cases meet the criteria outlined in USCIS's 2013 jurisdictional policy. NIP NLG has a resource on this topic that is very informative regarding JOP and navigating immigration court with child clients. Turning to some trends from the asylum office. In some stakeholder meetings, there has been discussion of a front log where there is a delay in issuing receipt notices after the I-589 has been filed. It may depend on the location of the asylum office, but practitioners have experienced a range in time in receiving receipt notices after the I-589 has been filed. Turning to the backlog now, generally the trend is that interviews are still being delayed in scheduling. And regarding scheduling and stakeholder calls, USCIS has stated that their scheduling priorities for asylum office interviews has not changed. I think the most notable update regarding asylum and unaccompanied children for 2022 was probably regarding the asylum-based EADs. This year, DHS reinstated specific EAD provisions, and these reinstatements are applicable to applications that have been pending with USCIS as of February 8th, 2022, or received on or after that date. These reinstatements are applicable to initial applications and renewals. So I'll go into initial ones first. For initial asylum-based EADs, under the new rule, asylum applicants can apply for initial EADs 150 days following the filing of their I-589s. Absent a denial of the I-589, USCIS should adjudicate the initial EAD application within 30 days from the date of filing. And asylum applicants who fail to file for asylum within 1 year of their most recent admission to the United States are not precluded from filing for employment authorization. Turning to renewals, under the new rule and the reinstatements, to renew an asylum EAD, the applicant must demonstrate that their I-589 is still pending. EADs are renewable for the continuous time period necessary for an asylum officer or immigration judge to adjudicate the asylum application and during the period of any administrative or judicial review. Asylum applicants who timely file an EAD renewal are entitled to a 540-day automatic extension if the renewal was filed between May 4th of this year and October 26th of next year. After October 26, 2023, the automatic extension will go from 540 days back to 180 days. So that's a pretty big time jump. And the CILA team, next slide, please. Thank you. The CILA team has compiled some practical tips for Asylum 2022, and I'm going to go over those really briefly. First, USCIS released new editions of both the I-589 and the I-765, as I mentioned in going over deferred action. These new editions were released in compliance with the decision in Asylum Works versus Mayorkas. Another tip is that USCIS has extended certain COVID-19 flexibilities, and they made permanent the flexibility to accept electronically reproduced original signatures on all USCIS forms, including the I-589. This is significant. If you have your client's original signature, you can use that signature, copy and scan it, and use it on other documents, which is very helpful in the virtual era of meeting. And lastly, we have some more practice tips. We did want to note that the online filing of I-589s is now available and it is an option, but it does have very limited applicability to unaccompanied children because unaccompanied children who are in removal proceedings cannot file online. They still need to file via mail. For more information about who is eligible to file online and who is not, please take a look at the I-589 instructions on USCIS's website. And if you have an asylum case, we want to encourage you to reach out. You can reach out to CGRS for technical assistance, contacting expert witnesses, and obtaining country conditions. But you can also reach out to CILA for technical assistance on asylum and other practices as well. CILA has resources for other practice areas and topics on our website, so please feel free to reach out to us directly. That wraps up asylum and deferred action. I'm going to hand it over to my colleague Serena to talk about UNT visas. Thank you.
Thanks so much, Sachi. I'm going to briefly go over UNT visas. There were not any major policy changes in 2022, so we're just going to provide some important points to keep in mind for each form of relief. So a reminder that in June of 2021, USCIS introduced what's called the bona fide determination process, where on a discretionary case-by-case basis, they may grant bona fide determination, employment authorization to documents, and deferred action. Bona fide determinations require that the U visa petition is properly filed, contains all required initial evidence, and that biometrics are completed. Just a note that processing times from the time of filing to the bona fide determination review on the USCIS website still say that they're around 60 months or 5 years. Second, USCIS updated its U visa law enforcement resource guide. So this guide provides law enforcement officials with information about U visa requirements, the law enforcement certification process, and answers to frequently asked questions from law enforcement agencies. Regarding T visas, in October 2021, USCIS added a section on T visas to their policy manual. So we want to highlight Section C on T visas because in recent years, USCIS has broadened their view of the physical presence requirement. So essentially, an applicant can demonstrate that their continuing presence in the United States is on account of the severe form of trafficking, and that it's directly related to that initial victimization by explaining that the impact of the trauma they continue to experience was a result of the trafficking. This also, the language in the policy manual also highlights a victim-centered approach and lists factors that USCIS will consider in making this determination. Also in October 2021, USCIS published the first standalone T visa law enforcement resource guide, which was also updated this year in 2022. Regarding USCIS's interpretation of the current USCIS policy, we also recommend that you look to decisions by the Administrative Appeals Office, or AAO, to better understand how USCIS is applying the broadened view of those requirements. Although these decisions are not binding on adjudicators, they are still helpful in interpreting USCIS policy. And we're going to end on some practice tips related to, I'm going to end on practice tips related to UNT visas. So first, we encourage you to be creative in light of the improvements in policy, and USCIS is currently more sympathetic. Second, it's helpful to cite to USCIS guidance in your submissions, whether that's the policy manual, non-precedent AAO decisions, The law enforcement guides that I mentioned, all of these are not binding, but they can be persuasive to use the specific language and excerpts of the government guidance in your documents to establish how your client is eligible for relief. Third, check in with your clients regularly. So given the long wait times for adjudication and visas, circumstances can change and there may be new eligibility for U visas, for example. And finally, screening your clients for T visa eligibility, or again, during those long wait times in cases, rescreening your older clients to see if there are any additional facts that you can uncover to meet that on account of requirement and potentially establish T visa eligibility for them. With that, I'm going to hand it over to Vicki and Laura to talk about immigration court.
Hi, everybody. Thanks so much. So yes, my name is Vicki Giambra. I am one of the managing attorneys at CILA, and we're going to turn now to changes and updates in immigration court and related proceedings. First, I'm going to talk about prosecutorial discretion, which has been on quite of a roller coaster this year. Rather than kind of tell you about the whole history of everything that happened over the year, I'm just going to mention where we are now, kind of at the end of the year. In June of 2022, U.S. District Judge Drew Tipton here in the Southern District of Texas vacated the Mayorkas September 30th, 2021 memo on enforcement priorities. And the U.S. Court of Appeals for the Fifth Circuit and the Supreme Court have declined to put Tipton's ruling on hold while the government appeals. So this means that the Doyle memo, which came out in April of this year, is also no longer in effect. But OPLA has made it clear that prosecutorial discretion is still a thing, and they are relying on their inherent prosecutorial discretion authority. On their website, they say that prosecutorial discretion allows OPLA attorneys to decide on which cases to focus their finite resources and how to proceed in individual cases in light of the facts and applicable law. So also ICE's OPLA prosecutorial discretion website has been updated to kind of reflect some of these changes. Next slide, please. So where are we on prosecutorial discretion? What does that mean? Well, the biggest thing that you should know is that prosecutorial discretion is being exercised at the local level. This means that there may be some inconsistencies as to how PD is being applied, but the local level is what is really important. And the local OPLA offices are or should be putting out their own guidelines as to how they want to receive requests and what should be kind of in those requests. Generally, OPLA should be employing a kind of traditional examination into PD requests. They should look at the totality of the circumstances, case by case, look at it case by case, look at the length of residence in the United States, the person's criminal history, if they have community ties, and not just whether there is an alternative USCIS application pending. Also, just as a general rule, we've seen kind of across several jurisdictions that they're saying that PD requests should ideally be filed at least 60 days in advance. One other thing to note, if the chief counsel or the OPLA TA in your area indicates that PD in general or a specific type of PD is not available in their jurisdiction as a general rule, this should actually be elevated to a supervisor. This is kind of not what the answer is supposed to be. So all things are supposed to be on the table. And also the AILA's National ICE Liaison Committee is also collecting this information to share with OPLA headquarters. So just a few things you can keep in mind there. So what are some of the issues that we saw with PD over this past year? Well, the first one I'm going to turn to is kind of fingerprinting. So under the Doyle memo and now under the inherent prosecutorial discretion that OPLA has, OPLA requires a background check on the individual who's requesting prosecutorial discretion. This actually created big problems for many unaccompanied children and many children in general, especially if they're under the age of 14, and youth that had not yet submitted a petition or application for immigration relief that required biometrics. For example, if you're just submitting an I-360 for SIJS, biometrics is not required with that application. OPLA indicated that if biometrics had been taken for the child, they will run these checks using those biometrics whenever possible, but recommended that children submit an FBI fingerprint report if they have not yet taken biometrics, and even said that it would make things go faster to submit an FBI fingerprint check, even if you had taken biometrics. So this created problems because for, the general wisdom says that for young children, their final fingerprints have not been developed, so they tend not to be fingerprinted. It's one of USCIS's and I think CBP's guidelines that they don't fingerprint children under the age of 14, although this may be changing. One of the other issues is that getting fingerprinted often requires showing photo identification, which many unaccompanied children do not have. Some OPLA offices were accepting police clearance letters, but this was and is varying across jurisdictions. So some jurisdictions are still accepting them, some are not. One of the other issues we came across is that OPLA was submitting motions for dismissal without contacting the child's counsel. So we, sometimes when you're looking at an immigration case, the better path is to continue in immigration court. So maybe you're close to a merits on an SIJS adjustment and the PD is the priority date is current. So you want to keep on with that, that case because it'll go faster. Or maybe asylum is the only option, or they have an asylum EAD that you want to keep. And if the case gets dismissed, that EAD will no longer be valid until will be valid only until its expiration date. As the client's representative, our ethics rules generally state that you are responsible for the strategy of the case, even though the client directs what relief they want to apply for. So part of zealous advocacy in upholding the client's expressed interest would be to fight OPLA on this kind of unilateral motion to dismiss, if it's not what is best for your client and their case. NIP NLG actually has a great example template for a motion in opposition. In cases where the respondent opposes dismissal, but the judge rules on OPLA's motion without allowing time for the respondent to file its opposition, you might want to consider first asking OPLA to join a motion to reopen or a motion to reconsider. But ultimately, members may need to file an appeal of the judge's decision, and the deadline for appeal may occur before the judge has an opportunity to rule on a motion to reconsider or a joint motion to reopen. So something to keep in mind. One other thing to remember when it comes to requesting prosecutorial discretion is that don't forget ICE Directive 11005.3. So although the Mayorkas memo was overturned, this ICE directive was not overturned, and it is something that you can still use. So it's using a victim-centered approach with non-citizen crime victims, and they include in the definition of crime victims in this directive people with U and T visas or applying for U and T visas, VAWA, and special immigrant juvenile status. So, it's a really good idea to refer to this memo, which, advocates that, that when looking at and when ICE is looking at these crime victims, that they should look at positive equities and the guidance to treat, with a victim-centered approach. And so it will give you some kind of additional arguments to add into your PD request. Okay, my colleague Laura will be discussing how EOIR has updated and reformatted the EOIR policy manual shortly. but I wanted to discuss a few memos that came out of EOIR over the past year. And as part of an attorney's duty of competency, it is a good idea to be aware of these memos and where they are located. So you can now find them in Chapter 10 at the new EOIR reference materials page. So it's Chapter 10 memoranda. Okay. So there's 5 different memos that I just want to cover here. Traditionally, per the EOIR policy manual, the default filing deadline or call-up date is 15 days before the hearing. DM 2204 returns that 15 days because under the revised case flow processing manual, they had said a 30-day default deadline. And when they revised the policy manual, they included this 30-day default deadline, but 2204 returns that to the 15 days. 2205 is an actually very short memo that literally just says that several prior PMs are canceled, which includes the prior PM 21-13 on continuances. Now, this is significant because the 21-13 required immigration judges to follow that very restrictive stance of continuances that came under matter of LABR. So a matter of LABR is still, unfortunately, good law. But this previous memo emphasized that IJs are not required to give continuances except where required by binding law. And it generally made continuances unfavored. By retracting that memo by retracting 21-13, they're kind of loosening that stance. Then you have DM 2206, which is about friend of court. And in this memo, EOIR returns to the friend of court policy set out originally in the O'Leary memo from 2014, which focused on proceedings for unaccompanied children. And although it was, this O'Leary memo was superseded in 2019, but DM 2206 brings back substantially the same guidelines and expands them beyond unaccompanied children to all immigration court proceedings. In the memo, there's a discussion of client competency and that friend of court can bring concerns in this area to the court's attention. It also mentions a Texas ethics opinion regarding friend of court in the UC context and reminds practitioners to ensure the client or child in our cases understands the friend of court's role and that they are not the attorney representing the client. Now, there has been a lot of outreach by EOIR on DM 2207, which is about internet-based video hearings with national, regional, and local stakeholder meetings. And so basically this memo goes over, internet-based hearings and when they can happen and what a judge is supposed to do. And generally the decision as to whether the people appear in court or remotely rests with the court and is made in accordance with agency policy and operational needs. But the immigration judge should accommodate a respondent's request to appear in court or remotely where appropriate. An immigration judge should also accommodate a request for a witness to appear remotely where such a request is reasonable. It also says that a request for a remote or in-person hearing must be made in writing 15 days before the hearing. Now, many people said, well, how do I know, whether the hearing is going to be in person or virtual? Well, the notice of hearing is supposed to tell you whether it will be in person or virtual. But as we all know, there's a lot of notice of hearings that went out without this, notation on them before this policy came into effect. So generally, the judges themselves, each IJ has their own preference as to whether they prefer hearings to be in person or virtual. And then on the EOIR website now, it came up last week, it says what each judge's preference is. So if you do not want that preference, you submit a motion for the opposite. The last memo I want to talk about is DM 2301 on the status docket, and it replaces the prior status docket memo 19-13. a couple of the interesting things that it says if an IJ has granted a motion to continue to wait for adjudication from another agency or for a visa number to become available, they are eligible, that person is eligible for the status docket. It specifically mentions SIJS, both while waiting for a state court order and while waiting for adjudication of the I-360, as well as waiting for the priority date to become current. And the same thing for the U visas. It will allow a status docket for while someone is waiting for certification, while they're waiting for adjudication, and while they're waiting for a visa to become available. So just some quick practice tips. Make sure you check with your local OPLA office to determine what their PD guidelines are. One solution that some LSPs have had to the fingerprint issue is train somebody at your LSP to take fingerprints so they can get the fingerprint card, FBI fingerprint cards done. Make sure you check UIR's website to determine the IJ hearing preferences and ask for continuances, status docket, and or admin closure in your PD requests. Dismissal is not the only option. And now I will turn it over to my colleague, Laura, to continue.
Laura, you're muted.
Thank you so much. Let me start over there and appreciate it. I was just saying thank you, Vicki. Yes, my name is Laura Egan, and I'm a managing attorney at CILA. We're continuing on with information about immigration court, and I'm going to focus now on two topics, some procedural changes at UIR, as well as some litigation updates. So first, regarding FOIAs at UIR. In March 2022, AG Garland issued FOIA guidelines to the heads of all executive branch agencies. And this memo directed applying a presumption of openness to proactively disclose information, as well as to remove barriers. In September 2022, UIR issued a notice regarding an update to the FOIA process. So requesters are now strongly encouraged to submit FOIA requests through UIR's public access link or PAL system. And starting just recently, December 1st, 2022, UIR will not accept these requests by email. I do want to just remind that there is a separate process for seeking a record of proceeding, an ROP, directly from court or the BIA, and information regarding that is on UIR's website. That happened last year. There have also been several changes at UIR. And so first, talking about the immigration court and BIA practice manuals. These are generally living documents, but they did have more updates than typical this past August. And this was after getting a comprehensive review and after getting feedback from stakeholders. Both resources now live on UIR's reference materials webpage. Both are downloadable and searchable in PDF format again, so that's good. In February 2022, UIR also made e-filing with the UIR Courts and Appeals System, or ECAS, mandatory for attorneys and accredited representatives for immigration court and BI cases eligible for electronic filing. So now it's required for all cases that are electronic. And UIR will complete electronic service on behalf of the parties for all documents that are electronically filed. So that is helpful. There have also been several updates to the UIR website regarding information that's shared, and there's more court information available now. The UIR operational status webpage is still a go-to source of information. This gives just general information about the courts regarding public health notices, COVID protocols. It also has a map. And so this has been up there for a while, but they keep adding more details and information. So it's useful just to be aware of that and to check it. So now you can click on each court to get a lot of information regarding each specific court. They also now have a court staff directory so that you can see names and phone numbers of the people at the court, judges, court administrators, IJ clerks. So that's really helpful contact information that's now available. UIR issued a memo in June of this year on pre-hearing conferences. And it states that immigration judges should actively and routinely encourage parties to engage in pre-hearing communications, both for the efficiency of the court and the efficacy of pro bono representation. The Immigration Court Practice Manual has had a section on pre-hearing conferences for a while now. I don't know when it was there, but it's been there for quite a while. That's not new. So that's just important to look at and be aware of as well. The information is in section 4.18, and it says that pre-hearing conferences are used to narrow the issues for stipulations between parties and to generally simplify and organize the proceedings. So next update or change is a new rule. So in September 2022, EOIR issued a new final rule, professional conduct for practitioners, rules and procedures, and representation and appearances. And this was effective as of last month, November 14th, 2022. And this permits practitioners to provide document assistance to pro se individuals before the BIA and immigration court. They have developed forms for this process, so you now have to enter limited appearance through new forms, EOIR 60 for immigration court and EOIR 61 for the BIA. You no longer have to become the practitioner of record or have to submit a motion to withdraw or substitute after completing document assistance. Like I said, the forms are now available on the online forms webpage of the EOIR's website. And EOIR also has a very helpful FAQ to guide practitioners about this new change. This is pretty new, so we're going to just have to see how this goes and how it develops. All right, so next I'm turning to some litigation updates. And I just want to first start this off by saying a couple general notes regarding these updates. I'm going to be doing a high-level overview of a few cases. We're not going to have time to get into a lot of detail here due to time. And I'm just going to focus on what these cases said, either from the Supreme Court or the BIA. So there are different circuit courts' take on the issues, but I'm not going to get into those. So remember to do your research depending on which circuit you're in, because there are differences in terms of how this is being applied and interpreted. So the first case is Patel v. Garland. In May 2022, the Supreme Court issued Patel v. Garland and held that federal courts of appeals are barred from reviewing factual findings underlying the denial of certain forms of relief from removal, including cancellation of removal, voluntary departure, adjustment of status, and then two waivers, 212H and 212I waivers. So this case has limited application and does not apply to asylum, withholding removal, protection under the Convention Against Torture cases, for example. The decision does not change the court's ability to review questions of law, constitutional claims, as well as mixed questions of fact and law raised in a petition for review. So that's important when framing issues in an appeal. Frame it as a question of law or a mixed question of fact and law rather than a purely factual issue if it's regarding one of these forms of relief. NILA has a very helpful practice advisory on this case, and it was also discussed in a recent CILA NILA webinar. And so these are two great resources that we recommend checking out to get more detail. This next case is a BIA case, matter of La Para. It involved an NTA without the date and time information, and the BIA issued this case in January of 2022. The BIA rejected notice-based arguments for rescinding and reopening an absentia order, even when the NTA does not have information about the hearing's date, time, and place. The court found that a respondent received sufficient written notice to support the entry of an in absentia order of removal, even if they were served with a non-compliant notice to appear that did not specify the time or place of the hearing, where they were properly served with a statutorily compliant notice of hearing specifying that information. So the BIA decided in the in absentia context that discrete act of notice in a single document is not required, and notice could be provided in a statutorily compliant NTA or in the subsequent notice of hearing. So this case itself does acknowledge that this is not how all circuits see this issue, but this is what the BIA found. So these cases that I'm going to talk about next also involve NTAs that don't include all the required information. So we're looking at matter of Michafor and matter of Fernandez. And just generally, the rules regarding the NTA requirements, again, are not jurisdictional, but claims processing rules. So these are rules that promote orderly progress of litigation. They require parties to take certain procedural steps at certain times. And generally speaking, if claimants properly raise these issues, The violation of the claims processing rule must be raised early on, and if not, it can be forfeited or waived if the party waits too long. So looking at matter of niche 4 is June 2022 BIA case. And in niche 4, we got some guidance on when it is that the party waits too long to raise the issue. So here, the holding is that a respondent who raises an objection to missing the time or place information and a notice to appear for the first time and a motion to reopen has forfeited that objection. So waiting to the motion to reopen stage is too late. Then we get some additional information in matter of Fernandez. This was an August 22 BIA case. And in this case, we get more information regarding, okay, well, when is it a good time to bring up the issue? So the holding here again states that the time and place requirement in the INA is a claims processing rule rather than a jurisdictional requirement. And it states that an objection to a non-compliant notice to appear will generally be considered timely if it's raised before the closing of pleadings before the immigration judge. So at that pleading stage is when it needs to be raised. And then it also states as another holding, a respondent who has made a timely objection to a non-compliant notice to appear is not generally required to show that he was prejudiced by missing that time and place information. So that's good. Don't have to show prejudice. And then it also states an immigration judge may allow the Department of Homeland Security to remedy a non-compliant notice to appear without ordering the termination of removal proceedings. And that's what they did here. That's what happened in this case. The case was remanded back to the IJ so that DHS could remedy the non-compliant NTA rather than termination. So maybe not what we would hope for, but just know that that was the remedy in this matter. So it's important to know again to raise the NTA issues as soon as possible and before the close of meetings. I think that's maybe the most important point that I'd like to make from this slide. And now going to go over a recent decision from Attorney General Garland. This was issued just last month, November 2022, matter of Coronado Acevedo. And in this case, matter of SOG and FDB was overruled. So that's good news. And now it also states, pending the outcome of the rulemaking process, immigration judges and the BIA may consider and, where appropriate, grant termination or dismissal of removal proceedings in certain types of situations. And those situations include where a non-citizen has obtained lawful permanent residence after being placed in removal proceedings, where the pendency of removal proceedings causes adverse immigration consequences for a respondent who must travel abroad to obtain a visa, or where termination is necessary for the respondent to be able to seek immigration relief before USCIS. So it's helpful just to be able to know those specific instances now where dismissal or termination may be appropriate and may be done. The decision, like I said, also notes that the department is currently undergoing reconsidering the regulations at issue in Castor Tom, previously overruled, and SOG and FDB. And so they will issue a notice of proposed rulemaking that would address the authority of immigration judges and the board to terminate removal proceedings. So there's more to come on this issue, and we should keep our eyes out to potentially provide comments once rulemaking is initiated. So for the final slide here, this goes over some practice tips. One is just, I recommend subscribing to receive published AG and BIA decisions from this. You can easily subscribe on EOIR's website, and then you can be notified via email anytime a decision comes out. There have been a lot of stakeholder meetings this past year, and CILA has been attending those, and recommend that you attend them too if you have time and interest, because as there are new updates and changes, those are typically reviewed and there's opportunity for questions. Also from the litigation updates, again, review those NTA issues early on, raise them early on. You don't want it to be forfeited or waived. And then if you are in immigration court frequently, the Immigration Court Practice Manual is your friend. And so it's easily found online. Again, now it's easily downloadable, searchable again, so that's helpful. And they also have a table of changes, which I like to look at just to see, okay, what were the last updates or changes that were made to the document, because it is a living document, so there's changes all the time. So that's very useful tip. And then, as you can see, I think for 2022, there's just been a lot more options for dismissal and termination, and that's just continued with this recent AG decision. And also to reiterate, we just covered these few cases, a very high level, and did not get into the different circuit courts' views on the issues. So do your circuit court research always. Thank you so much. And now I'm going to turn it over to my colleague, Marisa.
Hello, thank you, Laura. Wow, that was a lot of information, a lot of highlights that came your way. We all live our professional and personal lives in synchrony, which means that this was a whole year review, and not only on your hard work, accomplishments, and disappointments, and personal sacrifices and wins, but it was also a reflection of your whole work, right? Our brain catalogs events, memories in many different ways. One of those ways is by tying events to emotions, visuals, sounds, smells, etc. Have you ever had a smell, taste, transport you to a different time, place, or event of the past? You probably have, which means that it was probable that this webinar brought up some memories and triggered some emotions or feelings. Maybe it reminded you of an impactful case. Maybe it reminded you of a difficult or happy time or work at home. Just like it's important to take time to center ourselves and set intentions like we did at the beginning, it's also equally as important to reflect on our day or after a highly charged moment. If you haven't incorporated any of these habits in your life, as 2022 comes to an end, this will be a great time to try it. This tends to be a month where many emotions and thoughts come to the surface. Maybe it's the sensation of the passage of time, the ends, the beginnings, the farewells, what mobilizes these different emotions and moods. Of course, it is always rewarding and encouraging to achieve what we set out to do, but we must all be kinder to ourselves and less self-demanding and understand that life is not an easy thing to navigate. Self-reflection is not about self-punishment, blame towards us or others. Some say that what we label as bad, wrong, or a mistake is a lesson in disguise. The beauty of it all is that we can view this time as a new beginning, a new opportunity where new dreams, goals are born or others are updated. Next. After we conclude this webinar, I want to encourage all of us to carve some time to reflect before the day ends. I want to provide you with some tips on how to reflect and how this might look like. Daily reflection is best, but some is better than none. It does not have to be complicated or take all the time in the world. You can reflect while carrying out daily tasks such as while taking a shower, or your drive back home from a long day at work, while you drink your night tea, or minutes before sleeping at night. Pick a quiet place where there will be little chances of distractions or interruptions. Take several deep, nourishing breaths before starting. During your check-in with yourself, you'll probably have countless thoughts running through your head. Some of those thoughts will be happy and focus on a day you feel especially happy and made a difference in other people's lives. However, we are humans, and many of us tend to have the natural tendency to reflect on the bad things or on what went wrong, what bothered us, or our weaknesses. If this happens during your reflection, I want you to stop, take some deep, nourishing breath and reflect. Is all that true? Is that all you are? Challenge yourself and change your thought pattern and see what happens. At times you might feel as you haven't found yourself yet. You feel lost. Maybe your focus should shift from trying to find yourself to building or creating what you wanted your life. If you want to improve yourself, reflect on what you are trying to do, what you actually do, and what you want and what you can do to bridge the gap between the two. Ask yourself, what are my skills and strengths? What are my weaknesses? Who do I want to be? What are my passions? When do I feel better? What prevented you from accomplishing your goal? What can you change for next time? If you're not happy with a decision or an action, ask yourself, what actions can you take so that it does not repeat itself, or how you can mitigate the negative impact. Next. Remember, self-care is not only a good idea, but a necessity and a professional ethical obligation. It's so important that the Code of Ethics for both attorneys and social workers, for example, includes a section to address self-care. As service providers, we have the obligation not only to ourselves, but to those we serve, our colleagues, and our loved ones. Professional self-care is vital for competent, ethical work practice. The demands of work, challenging workplace environment, and exposure to trauma warrant that professionals such as attorneys, social workers, or social service providers maintain personal and professional health, safety, and integrity. I hope this encourages you to make self-care an essential component of your life. Thank you so much for joining us today, and you got this. Thank you.
Thank you so much, Marisa. With that, I do want to respect everyone's time. And if you do need to jump off, please feel free to. It'll just take a couple more minutes to wrap up. But we did want to share some of these great practical tips and considerations that you all submitted when you registered for this webinar. There is power in learning from each other, and we got at least 45 people who shared their practice tips. So that just goes to show how collaborative and supportive our community is. Thank you all for sharing, and we posted every single tip on here, so please take a moment and look through these when you have a chance. And now it's time for the victory board. And again, if you have to jump off, no worries, but please do take a moment to just appreciate and celebrate how far you've come this year, the work that you've done, and hopefully continuing to do the work. You can join the victory board here. There are instructions in the chat. You can either scan the QR code on your phone, or you can join at slido.com using and enter the code 1465376. I do want to give just a moment to folks to share if they want to. It's anonymous, and that you can share a personal or professional success from 2022 to share with this community. And I think I need to click again. There we go. Sorry about that. Great. There's already a lot of entries. So let's see. Lots of dismissals in immigration court, multiple T visa approvals. That's amazing for children who were trafficked in their home country. I see 2 asylum wins. Motion to reconsider at the AAO, and Atlanta IJ terminated proceedings. Congrats, everyone. Secured defective NTA. That is very cool. Email at that address if you want a copy of the decision. Thank you so much for the offer and collaboration. Let's see, there's so many. First T visa approval, how exciting. Michigan Court of Appeals win for MIRC, how great. Let's see, so many. Start a new job, yay. Deferred action for a client of 2 years. That's so exciting. And humanitarian parole petition for an unjust deportation under Title 42. This is so heartening and so great that you all are sharing. Really appreciate that. First year practicing immigration law. Congrats and welcome on having your first PD joint motion to dismiss. That's very exciting. And approved SIJS, tons of AOS and N400 approvals. DV asylum granted and several dismissals, lots of deferred action for SIJS kiddos, a lot of affirmative asylum for Afghans. That's amazing. Lots of positive movement this year, and it's really great to see everyone sharing between immigration court dismissals, deferred action for SIJ kiddos, and everything. I'm gonna give one more second, but I hope you all are able to take a moment either now or after this webinar to just celebrate the successes that we have seen this year, the hard work that we've done, and just keeping in mind that this work is very challenging, and it does require often it often requires us to redefine success. So keeping that in mind, let's see, I lost my notes, but in case there are any questions that we didn't get to in the Q&A, please feel free to submit a technical assistance request. You can either do that on our website or email us at CILA@abacila.org. And this can be a question that we didn't get to today on the materials or a case-specific question. And then we also wanted to provide a reminder that CILA hosts a pro bono platform called Pro Bono Matters for Children Facing Deportation on our website. Our goal is to match more pro bono attorneys with organizations' cases so that more children and youth have legal representation. So please check out the platform on the CILA website where you can express interest in a case. Additionally, if you are at a nonprofit and you are interested in posting children's cases that need pro bono representation, you can also email us for more information at probono@abacila.org. Let's see, I believe my colleagues have posted in the chat the links to our surveys, one for feedback, because we really do appreciate your feedback and take it to heart, and we'll keep it in mind for future trainings. And second, for the CLE credit, feel free to submit that if you are seeking credit in Texas, or if you're licensed outside of Texas, if you're seeking a letter of attendance. We welcome you to stay connected with us at CILA, either using by checking out our resources and recorded trainings on our website, attending future trainings, joining a working group, requesting TA nationwide, and finally signing up for our monthly newsletter. Check us out on social media as well. And with that, we are at the end of the webinar. Thank you to everyone again for joining us today. Again, the surveys are posted in the chat. So please complete the feedback survey, as well as the CLE survey for credit or a letter of attendance. With that, we are grateful for your presence here today, your participation. Happy holidays, and we look forward to seeing you in 2023.